Hey, Brittany, thanks. It's great to be with you all and give a little overview of military retirement benefits during and after divorce. Again, the military and service members and their former spouses face challenges that benefits that perhaps civilians don't. And so that's what we're going to talk a little bit, get a little overview, and then hopefully be able to answer your questions. So what I'm going to look at is we're going to cover military benefits. Obviously, what I'm looking at is being able to look at military benefits that are considered marital property. The 20-20-20 rule, which is actually a rule that applies to spouses of military while they're married to that member and what benefits they are entitled to. The 10-10 rule, the Uniformed Services Former Spouses Protection Act, and then Survivor Benefit Plan. Those are kind of the 3 or 4 areas I want to look at, and then hopefully give a good primer of how we can help. So we talked about certain benefits, and obviously the first thing I want to look at is this: service members and non-military spouses, they face challenges. And so one of the challenges, how do we delineate and divide these benefits? Well, let's look at military pension and look at retirement. And at military pension, normally you vest when you have at least 20 years on active duty or 20 years reserve or National Guard, and you are able to qualify for military retirement. Military pension, though, is considered what's known as shared property. What I mean shared property is that, in fact, that is that both the spouse and the military member share in that potential retirement benefit. In all 50 states, military pension, retirement pension, is locked in time as of the separation, divorce, or annulment date. And let me give you an example. Let's say that a spouse and the military member are married, and they get divorced when that military member is an E5, but later after divorce, that military member attains the rank at E8 or E9. That the retirement pension, if it's divided, would only be locked in as at the rank of the individual at the time of the separation, divorce, or annulment date. Another thing I want to tell you too is that as far as language in that, there is actually language in the National Defense Authorization Act of 2017 that specifically lays what that policy is. And if you would, let me just read you that language. It says that in the case of a division of military retired pay as property, where the service member is on active duty of the date of divorce, disposable retired pay is limited to the amount of retired pay to which the member would have been entitled using the member's retired base pay and years of service on the date of the decree of divorce or decree of divorce, dissolution, or legal separation, as increased by cost of living amounts granted by the military from the time of the divorce. So that's very important. Again, this is to ensure that while that former spouse may be able to get part of that retired pay, it's only when the time that he or she was married to the military member. That's very important. And I talked about, that's shared property. And again, what I mean by shared property is that it's property that is obtained either before or after divorce is referred to as separate property. But property acquired during a marriage is usually considered shared property unless it was received as a gift or inherited entirely in the spouse's name. Okay? So what is separate property that's not considered marital property, that can't be divided? Well, one of those is Veterans Administration disability compensation, or also combat-related special compensation. The courts have ruled, there's actually a Supreme Court case on that called Howell that said that if in fact you're not able to get service members veterans disability compensation pay or combat-related special compensation, that can't be included in terms of his retired pay. Now, and what happens, I've seen many times, is members will waive their retired pay in order to get full disability compensation or even qualify and be able to receive combat-related special compensation. Again, Veterans Administration disability compensation is awarded by the VA for disability service-connected injuries while on active duty or in uniform, combat-related special compensation, or for those injuries that were incurred while in combat or in training for combat. And so that technically you would have two tax-free incentives. A lot of times, you go. So what they'll do is they will, service members will waive their retired pay. And so again, you're not able to get that amount of money. And so what I've seen in many times is the individuals represented by a counsel will actually have an amount specified in a divorce decree. Anyway, what's the 2020 rule? And this is important because it is, I call it determinative of during a military divorce when deciding what a former spouse can have the same benefits as a military spouse. So it's important. The 2020 rule is a three-part rule. It says you've got to be married to the service member for 20 years. That in fact, that military spouse will have served in the military for 20 years, and 20 years of marriage overlaps with 20 years of military service. If you've got that 20-20-20 rule, then the former spouse that meets all these requirements, he or she will receive the same access to benefits as those as a service member, such as TRICARE, access to PX and BX privileges, and the military ID card. So that benefit stays with that spouse if in fact they've been married for the spouse for the 20 years that spouse was in the military for 20 and you had an overlap. And also, if remarried after 55, that former spouse doesn't lose the benefit. If the former spouse is married prior to that, she loses the benefit. But this is just has nothing to do with retirement benefits. It's just talking about the benefits that if a spouse, and the argument is that spouse contributed to the service member's military career success for those 20 years, and as a result, she or he will retain the military ID card, will have access to post bases and installations, will retain TRICARE until you turn 65, and then as you all know, TRICARE becomes the secondary insurance. I should know, I turned 65 a couple of years ago. The next access is this called the 10-10 rule. And all we're saying here is if the marriage to a spouse lasted 10 years and the service member of the former service member served in the military for at least 10 of those years, what is the spouse entitled to? She's entitled to, if in fact there is a division of retirement benefits or anything that's stated in the divorce decree that in terms of monetary amounts, he or she are allowed to go to the Defense Finance and Accounting Service, and they can have a direct garnishment or allotment out of that former service member's retired pay. Again, all it allows the former spouse to do is because of the 10 years of marriage, and you had the overlap of 10 years of marriage, it allows a direct payment from the former service member's monthly retirement amount from DFAS. And so again, that ex-spouse, former spouse, is freed from the need to rely on or wait on payments. You have to notify the Defense Finance and Accounting. And then I'd always argue that you actually include that in the divorce decree. But that's the 10-10 rule. Again, not entitled to benefits, but allows the former spouse to be able to get direct payment from the service member's retiree account directly because, in fact, he or she was being married to that spouse for 10 years. The Uniformed Services and Former Spouse Protection Act, I read part of it a little bit, but what it does is it was passed by Congress in 1982, and it provides some type of financial protections to some former spouses of service members. So it permits states to divide military disposable retiree pay as marital property. And so, again, we read the definition that was actually in the National Defense Authorization Act, but you can look at that bullet there. What is disposable retired pay? Defined as the total monthly retired pay minus deductions for retirement pay forfeitures following court-martial or deductions brought about by the military member's waiver of retirement pay, such as if, in fact, you're getting VA compensation and you're not at 50%, what will happen is the VA will take a portion of that retired pay out and then that'll be applied separately. But if in fact you're above 50%, you'd get concurrent receipt both of retired pay and full military, full VA compensation. So that's important there. So again, uniform former spouse protection. Okay. Again, this is the key here too, that a former spouse can take out child support of alimony from the military forces retirement pay, but it still requires a court order. And again, they can take it out of the retired pay, but you've got to be able to get the 10-10 rule for that former spouse to get the defense finance and accounting to actually go in that military member's retired pay and take it out. And finally, of note, according to the Uniform Services Former Spouse Protection Act, no more than normally you can only take out 50% of a retired pay. That's the most, but 65% of a retired pay can be deducted for spouse or child support obligations. But normally it's 50% is the maximum. However, if in fact there's allocations for child support and alimony, that can be up to 65%. Survivor benefit plan, and this is very important. I want you all to pay close attention because I've had a lot of dealings with this. So what is SBP? It's the annuity that a retiring service member can elect to ensure their beneficiary receives a portion of their retirement pay after he or she dies. But again, and you elect the SBP at the time of your retirement. A couple of years ago, we've had individuals that when they retired didn't make the election. And in past, if you didn't make the election, that was it. You couldn't re-elect, but they had open season a couple of years ago and you could go back in and pay a penalty. But that's over now. And so, but it is a specific benefit that you've got to elect at the time of the retirement from either active duty or immediately upon receiving the 20-year letter as a reservist. And it benefits the former spouse, the child, or any insurable interest. And if no beneficiary, you can elect to take later. But if in fact you take later, let's say that you remarry, you've got to make that election within a year after you in fact remarry or at least have a child. Here's what's complicated and misunderstood, and I stomped my foot many times here, and I've helped many a person out. Remember that you often, as a result of a court order, long before a service member retires, the court order orders that military spouse to make the former spouse a recipient of SBP, Survivor Benefit Plan. But remember, that order takes place, but it could be 10 years until the individual retires. So what happens? And this is the issue that I've seen, where what you have to do, you've got to, if in fact the court order deems that the former service member is going to make his former spouse the recipient of this annuity, this benefit when he or she dies, and it's placed in the court order, that former spouse has to deem his or her election, meaning they have to notify the Defense Finance and Accounting that in fact I have been awarded SBP, so as avoid any sudden changes by the service member when he or she were to retire 10 years later. And I've seen that many times where the spouse was ordered to provide SBP. It was in a court order, but because the former spouse did not retain a counsel that was familiar with military divorce law, they didn't deem their election. And so what happens is that then that spouse, when he or she goes to retire, changes the election to, let's say, a current spouse. Okay, and then you got a problem there. And so remember that the SBP doesn't kick in until that member dies. But who is the beneficiary? So we've had to go to the Board of Corrections of the various services to advocate for a spouse who either was not informed of deeming the election, or in fact was always told by the former spouse that they were close to, don't worry about it, I've taken care of you. They didn't perfect the election. And I caution people, you've got to when in fact it is ordered by court. Because again, if there's, and remember also, if there is no language in the divorce decree protecting that former spouse, that military spouse can make a new election and name somebody else as the SPP, as the beneficiary of the survivor benefit, the annuity when he or she dies. So, I always, I've written a couple of articles on survivor benefit plan. We've got a lot on our Tully Rinckey website. Look into that. I'm happy to talk about that if any issues. It's critical to know your rights when it comes to your benefits and seek, I think, good counsel. And even if a marriage lasted fewer than 20 years, the court may nonetheless award a portion of a military retired pay to the civilian spouse. Some will divide pension, others will cede pension rights in exchange for other assets. For example, I've seen many times, I won't make you the beneficiary of my SPP, but I'll take out an insurance policy for you, okay? But what we do in this firm is we actually advise the client and the client's counsel on the Uniform Services Former Spousal Protection Act. What language we suggest putting in divorce decrees. We're not getting into the state court itself. You've got to hire a civilian counsel there. But it's important because I've seen in many counsel not know the nuances of 2020, 1010, Uniform Services Former Protection Act, SBP. And those things we've got to be able to help those individuals out. So that's kind of an overview of where we are on military benefits. And if I haven't bored you to death, I'd be happy to take some questions and hopefully answer them. And again, note a compliment to the guys that put this together, Brittany and the crew. Thanks a lot, and we'd be honored to have you all as clients if you decide to call it. So Brittany, let me stop right now. Let me go to the next slide with the proverbial hands up, and any questions that are out there.
So it looks like we got somebody that's going to be typing out a question. So I'm just going to give them a few minutes. Anybody else who has any questions, please feel free to write them in the chat box now so Bill can answer them for you.
Pete, I'm sure your typing is faster than mine. Pete, it must be a very long question.
Yeah, I'm still waiting for it to come in.
Okay. Well, Pete's right. I have seen so many former spouses have problems with survivor benefit plan. Do deem the election. The Defense Finance and Accounting is rock solid. They're kind of like the Green Dot Bank, if you will. May I use that analogy? And so we've got to be able to convince them that's their regulation. Sometimes when they don't budge, we've actually had to go to the Board of Corrections for military record. And the issue is it's even harder when you've got two spouses that one believes is the beneficiary. It's easier when you only have one spouse, but again, you've got to deem that election. There have been Court of Claims actions that actually said we don't care what the DFAS regulation is. If it's in the court order, it's still going to apply, but you have to go through the appellate process there. I don't want anybody to have to go through that.
If a service member has already served 4 years with 2 combat deployments and gets married for 13 years and then divorced, will the service member completes 20 years of service, how will the spouse be entitled to property if the property was owned before they were married?
Well, you're going to look at, the time you were married, and the states had the ability to divide marital property, okay? And the time you're overlap is part of that marital, there's not a right to it, but the states had the ability to divide. Understand? And then in your case, Pete, remember that you're probably, I don't know how many years you got in, but you're also looking at possible combat-related special compensation in addition to VA disability benefits, in addition to maybe full retirement. And as you know, you can't have all three. You can't have concurrent receipt of VA disability, full retirement pay, and combat-related special compensation. You can only get two of the three or something like that. So what people do sometimes is they will waive their retirement in order to get the combat-related special compensation and the VA disability. But again, thanks for your service in uniform, Pete. But again, it's up to the courts as how they're going to divide. They're going to look at what the spouse contributed to the time in the marriage. It doesn't matter whether, in fact, she was there 20 years. If she was married to you until those 20 years, sure, she gets all the benefits as a military retired spouse. But in everything else, they're going to look at how long she contributed to the marriage. And while she was married, while you're in the military, or while you're drawing retired pay, that's shared property. Okay. God bless everybody. Take care.